I'm Issa, Hanna, and I'm joined here with my colleague Pooja Kohli. And today we're going to be speaking about the fiduciary investment advice patchwork of regulation that's now emerging at both the federal and the state level, and what we're looking to in 2020. So Pooja, why don't you go ahead and get us started with Reg BI?
Thanks, Issa. So regulation best interest is the new federal securities regulation that was adopted by the Securities Exchange Commission in June 2019. It's going to have a compliance effective date June 30th, 2020. So FINRA is going to take the lead on the examinations and start examining for compliance with regulation best interest later this year in June. As firms move forward towards implementation, we're going to be looking on the lookout for more guidance from the SEC and from FINRA in the form of FAQs, guidance notes, checklists, and even compliance outreach sessions. FINRA is also committed to providing preparedness examinations and reviews in the first half of 2020, so the first 6 months of 2020, where they'll be looking and talking to firms about some of the challenges faced with implementation. And off of the back of that, we're really looking forward to some kind of a report that FINRA will release that sets out common deficiencies and best practices for implementation. 2020, we hope also to see a resolution to the challenge that is being brought in the Second District to regulation best interest. So this should happen in 2020, but in the meanwhile, firms should continue to push forward with their implementation programs.
Great, thanks Pooja. And I wanted to quickly touch upon some of the state developments and also the Investment Advisers Act developments. So at the state level, the state regulators on the security side in Massachusetts, New Jersey, and Nevada, we expect them to push ahead with their fiduciary regulations. Massachusetts could be coming up with a final regulation in short order, while New Jersey and Nevada we think could be coming out with something final at some point in 2020 as well. As soon as those final regulations drop, we do anticipate that there will be challenges to those rules, so that's something else to look out for. From an Investment Advisers Act perspective, we anticipate that there will be continued focus and scrutiny of third-party compensation arrangements for investment advisors and the conflict disclosure that investment advisors make relating to those practices. We also expect to see a lot of examination focus on custodial and brokerage practices and whether investment advisors are meeting their best execution obligations, notwithstanding any kind of custodial or brokerage arrangements that they have and the conflicts those create. And we also expect the SEC to focus on duty of care issues for investment advisors, to examine investment advisors to make sure that the disclosures that they're making to their clients about how they meet their duty of care obligations, the type of services they provide to their clients, actually match their practices. So that's what we're looking forward to in 2020 from an Advisers Act perspective. Thank you for joining us. For more information on asset management regulation in 2020 and other bottom line videos, please visit eversheds-sutherland.com.